move on to our next speaker, which is Samantha Holman. And Samantha is the CEO of the Irish Copyright Licensing Agency, and she's a board member of the Irish Visual Arts Rights Organisation. She has also wide experience of teaching copyright law, both in Ireland and overseas, particularly in conjunction with the World Intellectual Property Organisation Development and Capacity Building Agenda. So I'd like to welcome Samantha. And if you can start, oh yeah, you've already started sharing your screen, fantastic. Okay, thank you very much, Samantha.
Unmute. Now, can you hear me now? Yeah.
Yes.
Good. That was the difficult part. Okay, thank you very much. First of all, I'd like to say thank you very much for inviting me to take part in this event. It's a really interesting event, and it allows me to look at what we do and how we support what you do from a different perspective. It's not one that I get to appreciate as often as I might like. So first of all, thank you very much for the opportunity to take part. I don't want to really say I feel like the fox in the hen house, but it is a slightly different perspective from me, and I'm definitely on one side of the copyright debate, if you like. But I hope that what I have to say will be of interest and will help create a conversation that we can continue after this event. I start almost every seminar I do about copyright law with the following quotation. By Kenneth Cruz, who was a librarian in Indiana University in the 1990s. He is still on the speaking circuit. I have worked with him on a number of occasions, particularly at WIPO events around the world. And he said back in 1992 that copyright is one of the most confounding and misunderstood laws affecting colleges and universities. This was true then, and if Chris Morrison's research is anything to go by, this is certainly still the case today, if not more so. As a partner in the education sector, our task at ICLA is to help your teaching and research communities navigating what can be this very confusing and intimidating space. So a little bit about where we come from. The ICLA license started back in the 1990s as a voluntary license. There was no broad exception for education in the legislation at the time. The legislation dated from 1963, when really photocopiers were even a rarity. Irish copyright legislation was updated in 2000 and came into effect in 2001, and it included a new exception for reprography, which was basically at the time photocopying. The exception, the 2001 Act really suffered from a timing issue in that it was introduced just really before the explosion of digital technology and our use of technology as we know it today. And therefore, there were some issues around wording in the legislation and how that worked in the real world. And one of the issues with updating copyright law is we're always on that back foot. The legislation is always behind the technology and the user experience and the user expectation. So our license was introduced in 2002, and it is an override to an exception, which means that if the license exists, then the user must have the license rather than rely on the exception. They can't fall back on the exception once the license is in place. We updated our license in 2006 with limited digital uses. And then in 2015, we created this integrated print and digital license, which combines the exception override for print and digital through voluntary permission. So it was kind of a hybrid approach to trying to make the license work when the legislation hadn't really caught up. In 2019, we had a new Copyright Act, which introduced a completely new and sweeping education exception at section 57, which replaced the old reprography exception and broadened the scope considerably to copying of a work for the purpose of education. And in September 2020, the government released the statutory instrument 277 of 220, which introduced the new licence. Unfortunately, everything went right up to the wire, and that was really due to the pandemic. Discussions with the department being able to move things, and I think civil servants working remotely, it made it very difficult for everything to get moving. So unfortunately, we've been very delayed coming into this academic year with being able to introduce the new licence. But it's there, and we are talking at events like these. We're talking at other events in universities and institutes of technology, trying to get the information out there so that you get the best use of it. So, updating the legislation. As I said, copyright law often seems to be on the back foot because it is always responding to technological change, which is moving much faster than any discussion about legislation possibly can. For example, in 2011, the government announced a review into copyright law. The report into the review was given back to government in 2013. Government announced that there would be new copyright legislation based on some of the aspects of the review, including education, in 2016. And the final act was signed on the 2nd of December 2019. Now, that's an extraordinary length of time in relation to technological change and how you wish to make use of the licence and make use of materials, and how teaching and learning has changed, and the acceleration of change in the last number of months. So the new legislation introduced a text and data mining exception, which will be of interest to researchers. It's limited to non-commercial, but there's a broad text and data mining exception. Implementation of the Marrakesh Treaty, which is the international treaty on access to content for the visually impaired. It included a much broader education exception, as I mentioned, including distance learning and web content. It updated the library and archive provisions. And one of the important updates is it has changed the language from librarians may make a copy to cause to be made, which will allow for partnerships with third parties in a much easier way and a clearly legal way. It also updated the legal deposit provisions to include non-print works, to include digital works, which is an update that has been quite a long time coming. So I thought it would be useful just to look at the information landscape and the type of work and how you can access works and what category they might fall into. Obviously, we have works which are out of copyright in the first place. So now the problem with that, of course, is that the term of copyright is the lifetime plus 70. So it can take a very long time for works to go out of copyright. It also can be very difficult to get permissions for works in that last 20, 25 years of that copyright term. There are works that are published as open access. You have open educational resources. You have materials under Creative Commons licenses. You have direct publisher license agreements. And then you also have the blanket license, which is our license, which is intended to support the provision of a variety of materials to students for the enhancement of teaching and learning. It is always intended to be supplemental to the primary market and not to supersede it. And it is on that basis that we are granted permission to operate the license by the publishers, by the exclusive rights holders. Copyright protected material available under Creative Commons license or open access are all interlinked and are fundamentally dependent on a licensed use supported by copyright legislation. Open and Creative Commons are permissions based on the exclusive rights, where you give the broadest possible permission that you can. So it all comes down to not a competition about copyright, but in fact, it is all integrated, and these are all based on an understanding of how copyright operates. And the fact that it's an exclusive right, which means you may give permission to do for it to be disseminated the way that you wish. And then there are other exceptions in the legislation around education in particular. So the exception that allows for putting material onto an exam, for example, so that you don't have to go and seek permission. So there's no possibility of the information about what might be on the exam being leaked. So I thought it might be useful, and being on Zoom actually makes you doing a lot of information on slides rather easier these days, because you tend to have it up much closer to you than you would in a conference hall. But this is an example of, for example, a reading list for social psychology, for example. And it gives you the example of books which are under the license, or something which has already been paid for, where the license is integral in the content. Journals, so a library resource, copyright fee paid copy made under the license, or links to open access articles. So it shows you that within a reading list, there are likely to be a variety of layers of how you are disseminating that material to the students. So I thought it'd be useful just to go back to what you can copy and what you can't copy, where we get it from, where we get the permissions from. So our repertoire under our license, it originated in a general mandate from authors and publishers back in 1992. We very much developed in parallel with advice and support from, and very slightly behind, the UK equivalent organisation, the Copyright Licensing Agency, or CLA. In 2001, post the 2000 Copyright Act, we started to seek individual mandates from authors and from publishers, and we have been doing that ever since. And we felt that the new legislation required more than a blanket repertoire or a general mandate. We had to get individual mandates, and that is what we do, and we are still doing. That is an ongoing work. Visual works appearing in publications are covered, and we cover that through an agreement with the Visual Arts Rights Organisation, which gives permission. And the share of the license fee for the visual works goes to the Visual Arts Collecting Society, and it is remunerated to illustrators, photographers, artists who have had works appearing in publications that have an ISN number through a scheme called Return. You can copy because the educational exception gives us this permission to create a license which covers as much of the exception as is possible. And then all of the international material that we cover through a range of bilateral agreements. One of the things we're working on at the moment with some of our bilateral partners is the difference between the fact that we now operate under this new broad educational exception and that our old bilateral agreements had more limited uses. So we're working with our bilateral partners to explain, and we will be updating our website with clarification about the works that can be used under the license and the bilateral agreements over the next few weeks. And this brings me to what you can't copy. There are certain excluded categories, which include things like maps and charts and grey literature. Our license really, for ease of management, covers materials that have an ISN number, whether it's an ISBN or an ISSN, or even, DOIs, etc. Any sort of identifier, and the identifiers are important so that we can then remunerate the author and publisher fairly for the use of their work. There are also some individual opt-outs, works which are excluded from the license, and those are on our website. They're at the beginning, they will be there at the beginning of the academic year, and the idea is you check that once, and that's it. There won't be other surprises coming, and it's a very short, small list. what I would say is if you are an institution that's using any of the management systems like the Digital Content Store or Talus, Aspire, the rules of the license are already built in, which makes it a lot easier to manage. So as technology changes, using our license and the rules of our license becomes much easier. How much can you copy? Well, you can copy extracts or parts of works, up to 10% or one chapter from a book, one article from an issue of a periodical, one short story or poem from an anthology, one court report from a collection, and the equivalent or nearest equivalent amount from born digital publications, including websites, per course of study, per academic year. The exception in the legislation that our license covers would only allow for 5% or one chapter per institution per year. So the license actually is much more generous than the original exception would be if the license didn't exist. We have had questions recently about the difference between per course of study, per module, where you have students who overlap from different courses doing modules. So basically, we would say it is per module, as long as students do not end up getting a substantial percentage of a work, which would effectively replace their need to purchase that work. So the module system is slightly more complex in defining how to use the license, but the idea is that you're not creating a whole work so that students don't have to purchase. So what you can do, there are a number of things that you can do. You can print enough copies for all your students, or you can just, which we're not doing at the moment generally, distribute digital copies to all students on a specific course via email or VLE, send to distance learners, send overseas to learners registered with your institution, copy illustrations without the related text, and you can alter, annotate and translate content as long as you're observing the author's rights, moral rights. And the moral rights are the right to be identified correctly as the creator of the work, and the right for the work not to be used in such a way that would damage the author's reputation. What you can't do, you can't put it on the World Wide Web, you can't throw it up on the internet, you can't throw it up on Twitter, you can't make it widely available, it must be closed access. Copy for commercial gain. This is one, I mean, education is not a commercial area. However, there are grey areas where there's an overlap between commerciality and non, and that was one of the things that was highlighted in Chris Morrison's research, was where do you draw that line? Is a conference that might make money a commercial venture because it costs less to run the conference than the money that came in? It's a really difficult one. It's not so much that it's difficult, it's confusing. And it's one of the reasons that this is something we really need to talk about more. You can't copy a whole work. And you can't create a digital archive beyond the specific course of study. So it's not around, you can't create a searchable digital archive from the works used under the license. One of the things that's come out of the pandemic in particular is this click and scan, or which is similar to a click and collect idea, but it's a click and scan service that a lot of university libraries are using. And I've seen the terms and conditions of some of them, and I've had queries about how this works. So we've had a look at it. And what we would say is there are two routes to content. There are two ways in which librarians can copy a part of a work and give it to somebody, make it available to somebody. One is under the education exception and the ICLA license, which allows you to copy parts of work to support teaching and learning. We would describe this as the push element. This is where material is identified, usually by the lecturers, and pushed out to the students. And it's pushed out to multiple people at the same time for the purpose of general learning. There is a library privilege. So there are two parts to exceptions in the Act that are relevant to you, which is there's the education sections, which are section 50 through to 57, and then there's library exceptions, which are the low 60s section, and particularly section 62 and 63, which allow a librarian to make a copy of an article in a journal or periodical, and to make a copy of part of a work, not defined, but to make a copy of part of a work for the purpose of research and private study. And that is section 63 and 62 are based on the use of a declaration that you ask the recipient to sign to say that they understand that they are receiving this for their own research and private study, and that as far as they are aware, no more than 2 other people will come and ask for substantially the same material at substantially the same time. Now, this exception is aimed, while education libraries may avail of it, this exception is really aimed at libraries which don't avail or are not in a position to avail of the broader educational exceptions to facilitate some copying by libraries to the general public. And we would describe this, I suppose, as the pull side of the door. And this is where individuals choose further material to support their own learning and research. So it's kind of self-identified outside of the reading list, outside of the material recommended to them by their lecturers. And this may also be used from the point of view of research. Having looked carefully at the legislation in the last few days, we would say that actually the digital scanning services can be done under the terms of our license, and there shouldn't necessarily be a need to rely on the separate library privilege exceptions, but they are there. So we're going to look at the terms and conditions of the scanning services that are currently on offer. I'm going to write a piece of guidance as to how to word that to support those as best as possible, and to make it easier for the librarians to manage on a day-to-day basis and to be clear about what it is you can't do. I would say the main difference is that our license is very clear about the amount you can use. It's the 10% or 1 chapter, and the library privilege in section 63 is part of a work, part of a book. So it's not as clear about the limits. And while I haven't had my 5-minute warning yet, I suppose I'm coming to the point of the discussion, which is where I would really like to have the discussion, which is in improving understanding. I was disheartened by Chris Morrison's research, or by the outcomes of Chris Morrison's research, and some of the examples that he gave of where really there is a lot of different interpretations of copyright in educational institutions. But I was also pleased that it's not just our perspective of that. It does underline that it is incredibly complex. It's not something that is generally somebody's day job to understand, and it would take a lot of time to do that. You all have to do your day jobs at the same time. So one of the things I would like to do is to talk about how we can improve understanding and create better materials, both from within CONAL and within ICLA, and on a wider basis, to help people understand and appreciate the importance of intellectual property, how it supports creators, owners, and users, and to avoid anxiety, misuse, or what we've heard of in the past, lack of use altogether of materials protected by copyright, because people feel that the license is acting as a barrier, as a stop. The use of the license is there to support routes to access to content. It is in no way intended to be a barrier to access. I have been thinking about how to describe it recently when preparing for this and for other sessions. One of the images that I was trying to use was, there's that story of the philosophy professor with the stones in the jar and then he pours the sand in. So to me, the stones are the material that you have, and the license is the sand that filters through it and fills that extra space where there might be confusion about how to get material out to your students. It is there to act as a support. And that's really the message we want to get across now. So I have now any questions or follow-up. I realize I've gone slightly under my time. One of the things that I have noticed now, I'll stop sharing. There we go. One of the things I've noticed these days is that I speak rather quicker on Zoom when I cannot see my audience. It's the one thing I find more difficult. I can't tell whether I've been clear or not on a very complex subject because I can't see the faces of my audience. So I've probably gone slightly under my time, but I'm happy now to take questions. And I see...
Right, Samantha, yeah.
Oh, I see a lovely one on the use of motion pictures.
Okay, yeah, you can see those.
Yes.
And you're able to answer those two questions that we have at the moment.
So I'll have a look at so please comment specifically from the ICLA perspective on the use of motion pictures. Well, not my area, thankfully. We represent the text and image sector and we don't represent audiovisual. Audiovisual is extremely complex because the layers of rights are complex. However, for the purpose of teaching and learning, there are two exceptions currently in the legislation that have always been there. One is that you can show something to a class, to a closed class, as long as there aren't members of the public, for pedagogic purposes, you may show something. And that is, let me just check specifically which section. So just bear with me. So it's section 55 of the Copyright Act. The performance of a literary, dramatic or musical work before a limited audience is permitted. But it must be in the course of the activities of it must be for pedagogic purposes. Then you have an exception that really is of its time, which is the educational recording exception. So that you could record on a VHS or and bring that VHS into the classroom and use it at another time. So it was a format shifting exception for the purposes of education. Also under the new section 57, you are allowed to take work from the internet. So material that is on YouTube, and without, there are caveats, I would say, in relation to identifying what is appropriate work on YouTube, because not all of it is there legally. But if audiovisual content is legally on the internet, and you're not having to go through some technical protection measure, or you're not breaching the terms of it's being used, then you can also use it in the class. So there are flexibilities in the new exception, which would allow for some audiovisual content. If you want to show films as part of a film club, then you require a license. And the current best route to look for a license for that is the Motion Picture Licensing Company, who offer blanket licenses to the HE sector. But that is for uses outside of teaching and learning. And that's really as clear as I can get. I don't speak on behalf of the audiovisual industry, and partly because, yes, Jane has put into the chat the paper by Emily Hudson, which I think also would be useful in this area. Exceptions allowed around supporting students with disabilities. That you, as an educational institution, you are one of the trusted institutions to make accessible copies. There are now new rules in the legislation now under the disability section Publishers will, going forwards in Ireland, be required to create a work in an accessible format that you can then use to create an accessible copy. One of the difficulties is that in order for the publisher to easily create a format that allows an accessible copy, they need to be using a workflow such as EPUB 3. Irish publishing is such a small sector, and even the largest Irish publisher is very small compared to the UK publishers, and certainly compared to international publishing, that moving to EPUB 3 is something that is extraordinarily difficult. So I know that some of the publishers who publish academic works, so Claris Press in the legal field, are looking at working with core text to be able to provide PDFs, and you'll be able to access the content that way. And one of the key questions I get from academics, if a book is not published in Ireland, does the ICLA license cover it? Yes, most likely. We have bilateral agreements with about 30 countries around the world. And if you have a country or works from a book published in a country that we don't yet represent, we can certainly go and look for that very quickly. We have contacts with 120 countries around the world that offer, that publish material. So yes, is the short answer. And yes, there are increased license terms during the pandemic under the ICLA license under certain conditions. So if you are using a system such as Talis Aspire or the Digital Content Store, then you may have, as in the UK, up to 20% of the work, or 2 chapters. But it's up to 20%. This is an extension to the terms that has been granted it was granted by the UK publishers and extended to the Irish license during the pandemic itself, and has been extended again for the 2021 academic year. And again, there's information on our website about it. If you are using that extension, you must be able to provide full reporting of the work that is used under that permission. So we have to be able to report fully back to the publisher what has been used under that extension to the license. But yes, we have an agreement that allows for that. Any other questions? Oh, I see Jane has mentioned she wants to do the copyright card game. Can I just say yes, we'd love to work with you on that.
Okay, brilliant, Samantha.
I have tried using it. I have used it.
Yeah, there was a plan a couple of years ago. Someone was adapting it, but I'll drop you a line. And
I think now that we have the clarity around the new legislation and the new license, it's a perfect time to try something like that.
Yes, I'd love to. Yeah, I'll be in touch. I've taken a note of your details.
Okay, Mick, any other questions or clarification?
I think that's everything. You answered the one about the disability
yes,
one, didn't you? Yes. So
disability used to come under our license when the legislation up to the end of August. It no longer needs to, because the new exception around disability is gives much broader permissions. So it no longer needs to. At schools level, there's Child Vision who do a lot of work. But, you know, having a discussion with Irish publishers and Irish universities about what would make life easier. The Irish Educational Publishers Association, which is schools publishers primarily, they have a statement and an agreement as to how they will release PDFs or other accessible format copies, or facilitate accessible format copies being made. But it's not something we've come across much for at third level at the moment in relation to Irish published works. But as I say, it's a particularly difficult space for small publishers to move to EPUB 3 from the workflows that they have been using historically. Yeah. But the UK works are generally in EPUB 3. I have come across some difficulties in people obtaining accessible copies from the UK in some of the health sciences, particularly where you have questionnaires for occupational therapists or people like that, that they, you know, that they're meant to use with clients, and that they have had difficulty getting accessible copies of those. But it is, you know, it's still a work in progress, but it is one that is improving.
Brilliant. Thank you very much, Samantha. That's the end of the first